Good evening and welcome to tonight's edition of the Political Persecution or Legitimate Prosecution. Tonight in focus is a trial of Ghana's minority leader, Dr. Cassiel Ato and two others for counts of causing financial loss to the state over the importation of 30 ambulances as part of a contract between the Ministry of Health and Dubai-based firm Big C Limited in 2012 for the purchase of 200 ambulances in all. Well, the trial took a dramatic turn last week. For which reason it's in focus tonight here on The Probe. It appears that the coming weeks, a lot will be said about this particular trial. It's gone on for 2 years and 5 months. That's where we are in terms of the status of this particular case. We'll get into some details, maybe a bit of background. 3 individuals were dragged to court on December 23, 2021 for allegedly causing financial loss of 2.37 million euros to the state in a deal to purchase 200 ambulances. I've been telling you about it. And this was between 2014 and 2016. Going on, these are the 3 key persons that started off this particular trial. Dr. Cassiel Ato, minority leader. He was a former deputy finance minister back then. Then we have Dr. Sylvester Anemana, is a former chief director of the Ministry of Health. Then Richard Jakpa, a businessman who was representing Big C. At some point, Dr. Sylvester Anemana was discharged. So he's not part of the case. Now we have Dr. Cassiel Ato and Richard Jakpa, the last man standing in this particular case. In 2009, that's when it all started. President John Evans Atta Mills of blessed memory announced the purchase of new ambulances during his State of the Nation address. Then Richard Jakpa, representative of Big C General Trading Limited, approached the Ministry of Health with a proposal. Then, 30th April 2012, Ministry of Finance and Ministry of Health applied for parliamentary approval for the supply of these 200 ambulances at 15.8 million euros. Then there was a memorandum to Parliament, but did not reference the role played by Big C General Trading Limited and terms of procurement. These are the basic facts we go into. In November 19, 2012, Dr. Sylvester Anemana then wrote to the PPA seeking approval to engage Big C through single sourcing. And these are all fact sheets that we are getting from the Attorney General's Department. Then December 19, 2012, the Ministry of Health then finally or formally contracted Big C Trading for the supply of the 200 ambulances. Then fast forward, the 25 vehicles were to be delivered with 120 days of the execution of the agreement. Remaining 175 was in batches of 25 every 30 days. So this was the agreement. Then August 7, 2014, Dr. Forsen wrote to BOG for letters of credit of 3.95 million euros for 50 ambulances in favor of Big C General Trading Limited. Now going on. This was in 2014. Then in October 22, 2014, a consignment of 10 ambulances, which was shipped from Dubai on October 22, 2014, arrived. And it did so on December 16, 2014. Then February 12, 2015, the 10 ambulances, we're told, had defects. 20 additional ambulances that were also brought in had defects. So 30 in all had these defects. Now, a total amount of 2.37 million euros were paid for the 30 vehicles, which we are told had defects. Then, January 20, 2016, we had the health minister back then, Alex Segbefia, in a letter told Big C that the vehicles did not meet ambulance specifications. So these are the cases, the issues that have come up with this particular case from the very onset. Now that you have the bigger picture, let's talk about the status of this particular case. So the state has closed this case. We know that Dr. Ato, the first accused, has also closed his case. Second accused, Dr. Sylvester Anemana, we know has been discharged, like I told you earlier. Now, third accused, Richard Jakpa, brings new claims last week, just when we're hoping that the case will be finalized. Richard Jakpa, during the cross-examination, claimed that the AG has been reaching out to him to give testimony that will incriminate Dr. Ato, the minority leader, who is also the first accused. Well, he was very angry in terms, at least, we've seen the proceedings in court as was transcribed. And the NDC has been reacting to the claims made by Richard Jakpa. The AG has also denied the allegations. That allegation was made in open court, but the AG did not react or respond in open court or deny the claims that Richard Jakpa made in open court. But subsequently, there's a statement that has been put out by the AG's department claiming that Richard Jakpa rather reached out to his office to engage a plea bargain, but that has not been accepted because it was not put the way it ought to have been put. So these are the issues that have come up. The judge early this year scheduled conclusion by May of this particular matter. The deadline we know has been missed. She has now said the case will not exceed July. But with the sudden turn of events and the bombshells in court, we don't know if that July deadline will also be met. But my guest tonight will be interrogating some of the issues amidst the claims about some leaked tapes and evidence that Richard Jakpa is going to be putting out. The NDC has also mentioned that they will be holding a press conference. There's a talk about a meeting that happened in the Supreme Court Justice's house, amongst others. These and more are issues that are coming out regarding this particular case involving Minority Leader Dr. Caesar Atuforsen. Well, my guest tonight, Isaac Wilberforce Mensah, is lawyer, spokesperson to the Office of the Attorney General and Ministry for Justice. I also have via Zoom Samson Ladi-Anyenini, is a lawyer, he's host Newsfile and The Law. And joining me in studios is Justice Sremsai, is lawyer, senior lecturer, University of Ghana School of Law. We are live on the Joy News channel, on Joy 99.7 FM, on DSTV channel is 421, Go TV is 125, also on myjoyonline.com. Feel free to share your thoughts and your comments with us via social media platforms. We're on Facebook, we're on X Spaces, and all social media platforms there. You can just hit us with the hashtag, The Probe. I am Emefa Apau, and this is The Probe. Let's get talking right after this quick turnaround. Please do stay with me. Welcome back. You're live here on the Joy News channel on Joy 99.7 FM, and this is The Probe. And tonight we're taking a look at the trial of the Minority Leader, Dr. Caesar Atuforsen, and Richard Jakpa, this case of the ambulances, and then the twists and turns in this particular case, whether it is indeed a political persecution or legitimate prosecution is what we are looking at. And Samson Ladi-Anyenini is with me via Zoom, and Mr. Sremsai, Justice Sremsai, is also in the studios with me. And along the line, we're expecting Wilberforce Isaac Mensah to also join us via Zoom. Mr. Sremsai, thank you so much for joining us here in the studios.
Thank you very much for having me.
Okay. Let me check on Samson as well. Samson is joining us via Zoom. Hello, Samson.
Hello.
Good to see you, Samson. So let's start off, really. I'm hoping that we have a number of lawyers on the show tonight, but you will try and break it down for us and speak normal language so that we can all follow with this. But let's start with the allegations or the outbursts in court last week by Richard Jakpa. Really, are these allegations or outbursts some have described as from a frustrated accused person? Is it something that we should be going with, especially when no evidence was provided in court? At least, as we speak, there's no evidence.
Thank you very much. It is a very disturbing development, and we all need to admit. In respect of what was said in the courtroom, when a person enters the witness box, whatever he says is evidence.
Okay.
It may be subjected to tests to see how solid it is, but whatever he says in the witness box is considered as was evidence. Unless contradicted, it becomes, what the court will work with. So it is not exactly accurate when we say it is not.
So that's because he sworn an oath.
An oath.
Okay.
So that's evidence. So that's the first point. But he definitely would be someone who was frustrated at the time. The cause of frustration is something that we out here cannot point to, but clearly from the record, he appeared to be a bit frustrated. And he actually said it himself. If you look at the record, he said it himself. But the substance of the allegation he made is a serious one, which even for ordinary lawyers, and when I say ordinary lawyers, I mean lawyers who don't hold any high office as that of the Attorney General. If such allegation is made against you, the consequences are very, very severe. In the sense that when a court is, especially a criminal court, is trying someone, it is the person's liberty which is at stake. And the principles of criminal justice is that the proof must be beyond reasonable doubt. And further, that it is better to convict, to let 100 guilty people, go than to convict an innocent person. So the courts are very, very strict and are very interested in the quality of evidence which is brought before them, upon which they will make, conviction or acquittal. Now, the allegations seem to suggest that some pressure was brought to bear on the witness to say something other than the truth, or to say something other than what he would have said if that pressure was not brought, or to bear on him. That is a serious issue in the sense that when a person, whether lawyer or not, tries to, get another person to lie to a court for whatever outcome, there are strict punishment and rules against that. Now, making that allegation against no mere a person than the Attorney General, that is serious. And I think that the Attorney General knows that it's a very serious allegation. That is why when you, after the proceedings, you would see that there has been concerted effort to at least have some say in the matter, even though the records in the court show that much was not said in the court. After the court, I believe the Attorney General acknowledged the severity of the situation and has been taking steps to whittle down the effect or to actually neutralize it. So if you ask me how serious it is, that is how serious it is. It could lead to so many things.
But the response in itself is something that would interrogate, the response from the Attorney General, whether it actually speaks to the allegation that was made in court is one of the issues that we'll get to look at. But something, it appears that when Mr. Jakpa started making the allegation, the judge intervened, asked him to sit down for a bit. He says, "My lady, I'm a little bit uncomfortable." And then was asked, "Why are you uncomfortable?" He says, "I'm angry because how can he accuse me of to be defending A1 when I'm here to fight for my liberty? And he's been impressing on me to cooperate with him so that he can put A1 in jail, and I refuse. So he comes here to accuse me of defending A1. It is unacceptable." He goes on and says, "If he dares me, I'll open the Pandora box here, and I have evidence for that." Really, is it just a frustrated, accused person in court making wild allegations, or there's something actually in there?
Well, whether there is something in there or not, you and I do not have the mystical powers or the divine capacity to be able to tell. We are unable to foretell. Again, the courts do not deal with the metaphysical. They deal with the physical because they do not have the capacity to deal with the metaphysical. So from the record of what happened in court, it appeared very clearly that this is a witness who got frustrated, who got angry, but the pronouncement that proceeded from his mouth in the course of his testimony, and as Justice Shamsai has said, the media gets it wrong when he says, "Oh, he said something without evidence." What he's doing in cross-examination is evidence. The weight of the evidence will be determined by the court itself. Now, when he says the things he says, and as Justice has mentioned, and as I tried to give the education yesterday on Newsfile, when he says the things he says, and they are not about any mere lawyer, but the Attorney General, who doubles as the Minister for Justice, whose office is a constitutional office to start with, and who exercises such wide powers. Criminal prosecution is initiated at a suit. There will be no criminal prosecution in the Republic without the Attorney General, according to our Constitution. So our Constitution actually says all criminal, and in fact, also all civil cases, for as long as they are against the Republic, they will be against the Attorney General. So that is the weight of the office. The Attorney General is on several committees and boards, very sensitive and serious ones. And the Attorney General represents you and I out of this country by virtue of his office on international committees, panels, and to countries in our name. So if such an allegation bordering on crime, as far as sections 213, 212, and 213 of the Criminal and Other Offences Act are concerned, when, and again, the witness too must be presently aware that if what he's saying is lying on oath, then he could also be caught by section 210 about perjury, which is lying on oath, which is a second-degree felony, which means he could be looking up to 10 years in jail. So he may be frustrated. But to say the things he says and considering the consequences of the things he says, I would think that they are serious enough, warranting the attention of the right institutions for what has to be done. If you are even, like Justice says, an ordinary lawyer, the rules or the code of conduct for lawyers is very clear about a number of things. It says in section Rule 13, Rule 13 deals with communication with represented person. That is someone who has a lawyer. The rule says, I quote, a lawyer shall not approach, communicate, or deal with a represented person, that is a person who has a lawyer, on a matter or attempt to negotiate or compromise a matter directly with a represented person. The only exception is that you can do so through or with the consent of the lawyer of that person.
Okay. Well, you can wrap up on
that. I was going further about the law again. In Regulation 40, specifically about the Attorney General and how it works as prosecution. It requires the Attorney General to conduct prosecutions honorably with fairness.
Okay.
And then says, quote, a prosecutor in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by facts. So if there's an allegation that you are seeking to get someone to give false information or witness, then the suggestion is that you don't believe that you have a case. And if you do not have a case, the regulation says don't go on in the first place. And it proceeds to say that you shall not make, you shall give the other party adequate disclosures and timely.
Okay.
So that even if there is evidence that inures to the benefit of the opposing side, the person you are prosecuting, there is evidence that mitigates or negates the guilt of that person, the law says you should make it available to them.
Okay, but then so I will come to this, Samson.
Alleged.
Samson, let me come in briefly on this, because the concern then is this is the Attorney General. He ought to do anything and everything to get to the bottom of a case, for instance. The key question that many ask is, what exactly did the Attorney General do wrong in all this? Because it's coming up in the last few minutes that he was invited to the house or the home of a Supreme Court justice, and then Japa emerged and then raised the issue about his request to the AG. Really, in all this, what did the AG do wrong?
Yes, so let's split the things that the AG has done into two. The one which is an allegation in the courtroom is one. Let's put that as one.
Yeah.
And then what he did after the allegation, after the court proceedings. Now, in respect of the allegation in the court, those are things that, at least on the records, he has not denied them in the court. But we believe that he may be given an opportunity to speak to that. Currently, we don't have any clear procedure for testing something. This is very strange. It's actually something very new in our jurisdiction. We know of what we call mini trial when someone adduces evidence which police evidence. There is a process called mini trial where we stop the main trial and hold a trial to determine the verity of or the veracity of what the allegation is about.
Yeah.
But we don't have a similar thing for this. So clearly, we have to find a way of resolving this. Now, one of the ways of resolving this would be, and there are different views on this, that the Attorney General may be referred to the disciplinary committee of the General
Which we have heard the NDC say they may do.
Which would be, I mean, whereby the committee will hear evidence, will take evidence and give sanctions if they find out to be true. There's another school of thought which suggests, which I belong to, that the Attorney General is not necessarily subject to the disciplinary procedures of the General Legal Counsel, in the sense that because the Attorney General is a constitutional office and the General Legal Counsel itself as a whole is just a statutory body established by Parliament, and secondly, the Attorney General doesn't take licenses. He doesn't practice with a license in the sense in which ordinary lawyers practice. So even the GLC has no specific rules for such.
But he's a lawyer and a leader of the bar.
It's the same as saying that the Chief Justice is a lawyer. So if he does something, you drag him in there. So the fact that he's a lawyer he's not acting in a typical lawyer sense. He's actually a government official who is performing some constitutional rule. So the same regime, I think the same regime may not apply. What then this means is that in terms of such bodies, you have Parliament having oversight because the Attorney General is part of the executive. And in the broader structure of government, in terms of constitutional law, Parliament has oversight, on the executive branch of government, including what the ministers do. So in that respect, I foresee a possibility of Parliament actually holding the Attorney General and, initiating an inquiry into this proceeding, into this issue, to find constitutional sanctions for the Attorney General, or not necessarily sanctions, but to have a more constitutional inquiry into the matter and ascertaining whether it is true. And if it is true, then sanction will follow. Now let's come to the second set of transactions, that is what happened outside the court.
Yes.
The first thing that came out was a letter which was written on behalf of the Attorney General by his deputy, trying to explain certain things in relation to what happened in court earlier in the day.
And other matters.
Now, I was surprised to see such a letter because every paragraph of that letter further implicates the Attorney General in other things. So if you take paragraph 1, for instance, the letter the press release seemed to suggest that the Attorney General has enough documentary evidence to convict, and that there was no need, so he is so sure that those documentary evidence, those documents the record as he called them, will be able to convict the accused person. Now, the problem with such statement, especially coming from the Attorney General, is one, it prejudices the case before the court. Because you are basically saying that I have solid evidence which can convict the person.
And what's wrong with saying I have solid evidence? You have not put the evidence out.
There's absolutely nothing wrong in saying you have solid evidence. But when you are a lawyer and you go out to say such a thing, the code of ethics tells you that don't be making such prejudicial statement. Secondly, when you go through the other paragraphs, you will realize that there is some deliberate attempt from the Attorney General to convince the public that the accused persons are guilty and have been begging him to stop prosecuting them because of their guilt. And what are these things that he pointed to? One, a plea bargaining,
and
discussion.
Yes, followed up with the letters.
Let me take this opportunity to educate the public on plea bargaining. So, plea bargaining simply means that an accused person, could enter into a discussion with the prosecutor. And when you do that, the ultimate effect will be one of these three things. Either the charges are dropped completely, either the charges are reduced in terms of number, or either the charges are reduced in terms of severity. These are the three outcomes. In all this, until a plea bargain agreement is reached and presented to the court, the law says that the accused person is innocent. Now, what the Attorney General did, which is unethical, is to put information out there suggesting that these guys were guilty. That is why they even came to enter into what? Try to have a discussion with me on plea bargaining, which is not the correct statement of the law. And that also further prejudices the accused person, not just in the eyes of the public, but also sometimes in the eyes of what? The court.
But to the extent that this particular settlement plea was initiated by Big C, which are not parties to this particular case in court, could it also not have any effect on this? Because really, they started it. It's not Japa's company that started it. It was Big C. But they are not party to this particular case.
Well, first of all, if they are not party to the case, why did we even entertain them in the first place?
But they went through Japa.
Yes, so they went through the Japa's lawyers. So when you saw the letters that were released, they went through Japa's lawyers to make that proposal, which is something that every accused person is entitled to.
Okay.
And if you're entitled to such a facility, the law says you are not guilty by what? Suggesting, plea bargaining. And secondly, the fact that the plea bargain failed itself should tell us that then the matter must go to trial and the accused person is supposed to be what? Innocent until proven guilty. Now, so what that particular thing did was to throw some doubts or to prejudice the case for the defense, and plea bargaining discussions are not supposed to be put before the court because of the capability of those materials to prejudice the court itself.
Okay.
Now, Attorney General found a way of releasing these things into the media. And once they're in the media, chances are that it may get to what? The judge who is presiding. It further worsens the situation that we're trying to what? Prevent. Then on top of all this, another paragraph in the case suggests that the Attorney General actually entertained some conversation where one of the accused persons he recorded one of the accused persons on video,
yes,
begging him. And that is quite, severe because the Attorney General knows the position of Ghana's law on secret recordings, right? And to openly admit that you did something like that. You did not do it in terms of fighting any crime, but you put it out there to create a narrative that, oh, this person is even guilty, he came to beg me.
Was he not pushed because of the immense pressure that has been brought to bear on the AG? Maybe I would have to bring in something on this sure, as well, on that secret video evidence note that is also in that statement. So Samson, responding to the issue about what exactly the AG did wrong, he was trying to, prosecute a case which most people are now saying is a political persecution. Really, what did he do wrong? Is he not supposed to meet Jakpa at all? What exactly? You've been quoting the etiquette and the code of conduct for your profession. Really, he was not supposed to meet the accused at all. He ought to have done that in the presence of his lawyers.
Because you just mentioned the question of secret recording, I just grabbed my constitution and I'm referring to Article 18. Article 18 says every person has a right to own property, either alone or in association with others. No person shall be subjected to interference with the privacy of his home, property, correspondence, or communication. No person shall be subjected to interference with the privacy of his home, property, correspondence, or communication. That's what Justice Shremsai is stressing to you, that an Attorney General is bound by this Constitution. And guess what? This is found in the Fundamental Human Rights Provision. And in the Fundamental Human Rights Provision, the law opens by saying that persons such as the executive, officers of the executive, the legislature, and the judiciary, and all other organs of government and its agencies, and where applicable to them by all natural and legal persons in Ghana, they are supposed to do what? Uphold these provisions. You are supposed to uphold them. Okay. You cannot be breaching them. There is an exception, though, that if the recording is done in accordance with law, and if it is to serve certain purposes, including for the prevention of crime, then it doesn't matter that you are breaching that right. The law allows you to breach it. But talking about having conversations with the accused person for the purposes of plea bargain, we are getting the context, and the context suggests that the said conversations that the accused person is talking about happened after the attempted settlement broke down. Mm-hmm. So it will be difficult, if that is true, to prop up a claim that the said conversations or interactions and meetings were intended or in furtherance of a plea negotiation. Now, it is even absolutely wrong to start with. The law says, the plea bargain law is section 162A. That is an amendment we have done to our Criminal and Other Offences Act. This is a very fresh law, 2022, and it was actually spearheaded by the Attorney General himself, a very good thing that he did. I read to you. It says that a person charged with a criminal offense, is Jakpa charged with a criminal offense? Mm-hmm. I need an answer. Is he charged with a criminal offense?
Yes, he is. Isn't that what we are looking at right now?
Good. So it says a person charged with a criminal offense may at any time before judgment. We haven't gotten to judgment yet, have we?
No.
Good. May at any time before judgment negotiate with the Attorney General for a plea agreement. But guess what? The law says he cannot do it by himself unless he's not represented by a lawyer. So the law says where the accused person is represented by counsel, the plea negotiation shall means mandatory, shall be between the prosecutor and counsel for the accused person. So on the basis that these allegations are proven to be true, then to start with, this is where the law would be breached. And therefore, the expectation will not be that what is conveyed by this press release or the letter will say that, oh, we were speaking with the person alone and without his lawyer, calling the person on phone alone. And remember what I read to you earlier said, you don't even approach them. Okay. You don't approach them. You don't communicate with them.
But Samson, it is emerging in the last few minutes that one of the meetings, so I don't know if there are other meetings, but at least this particular meeting that was held in the Supreme Court Justice's home or house was not at the instance of the Attorney General. At least he was invited to come to that particular, residence, and Jakpa emerged. So how then do we fault the Attorney General in this particular situation?
You are telling me this. I do not intend to fault anybody. I am only linking the situation, situating the story as we have heard, the narrative as we have heard, so, with the law, within the law, and to share what the law prohibits and what the law does not prohibit. Now, imagine that whatever the circumstance of the meeting is for the purposes of furthering the plea negotiations. Maybe because there is no that allegation of an attempt to ask one person to falsify information or tell falsehood to implicate somebody, there would not be a problem. But if it is proving that at this meeting the discussion and the content of the discussion was that implicate this person so that we can let you go.
Okay.
It's like what we call the poison fruits. Implicate this person and let you go. We will let you go. Then that will become in the realm of the criminal law, which we are all bound. And in the criminal law, once again, in section 213, it talks about fabrication of evidence. Let me read it to you. Briefly. It says, whoever fabricates evidence with intent to defeat, obstruct, or pervert the course of justice in any proceedings shall be liable to the same penalties as if he had committed perjury in that proceeding. Perjury is lying under oath, and it attracts, in some circumstances, it can attract the penalty given to someone who has committed murder.
Okay. Well,
but in this circumstance, it's under second-degree felony, which means the sanction will be up to 10 years in jail. So this, if this is what happened, once again, it ought not be the case.
Okay.
Our rules that I was reading to you earlier actually says that if you are the one doing the prosecution and you discover there is some evidence that goes to negate the guilt of the accused person, you should make it available to them. In fact, the law goes ahead to say that if you are done with the prosecution and you find later that the person was found guilty on the basis of some information that was false, some document that was not correct, the law says you should take, as the Attorney General or the prosecution, you should take the immediate steps to get that conviction reversed.
Okay. Let me bring in Mr. Shremsai on this. Really, the concern is also the impact of this particular development on the case going forward is a key issue. At least we've heard the NDC raise concerns. It looks like more like a political persecution rather than a prosecution. What for you will be the impact on this case going forward with all this development coming up? And also, don't forget, I've just been telling something about the fact that it's coming up that, in fact, this particular meeting where the recording is emanating from was at the instance of a Supreme Court justice and not the Attorney General.
So, thank you. The issue about impact, the essence of criminal justice is fairness, absolute fairness. So that even if you are convicted, you would be satisfied within yourself that you have been given all the opportunity to present your case, to cross-examine those who accused you, to test every single evidence. So by the time you are in jail, even you, the accused person or the convict yourself, you should be satisfied that they have given you fair hearing. Clearly, the things we are seeing, and the one you just mentioned, everything is showing that this trial has very little fairness in it. Because, you see, the presence of the Attorney General alone in the case is enough to tilt the scale. Now, we are not just having the Attorney General alone in the case, but all these background meetings, significant persons in society, which the Attorney General himself complained of again in his press release, saying that people have put pressure on him to allow the persons to go free and all that. It all tells you that the case is not, I mean, if you convict these persons with this, that element of fairness will be completely missing. I mean, the Attorney General himself is saying now, with new information, that he has been entrapped, or there was some elements of entrapment in his conversation at the Supreme Court Justice's house, and there were some recordings, and then the accused person is also complaining that he's been forced to say things that he wouldn't have said, and then everything put together is creating a very bad impression, not just of the case, but also even the justice system. And particularly on the Attorney General as an officer of the court. It is really creating a very bad impression on them. And the consequence, the consequence can be in other jurisdiction. in other jurisdictions where rule of law is taken a bit more seriously, in a jurisdiction where criminal justice is respected, the right of the accused is respected, what would have been done immediately was to enter mistrial for the trial to begin again. And then the person who was prosecuting the case, in this case, the prosecutor, would be taken off and a new prosecutor brought. Unfortunately, in this situation, the person who is being accused is the one who is holding the whole prosecutorial power. So changing him, you cannot just take him from the case and bring his subordinates to come and conduct the case. What it means is that if you really want, in those jurisdictions, if you really want this particular trial to go on, then you probably would have to make top changes in the Attorney General's department. And in this case, the person who is really in charge must go. We don't know, like I said, this has never happened in our jurisdiction. I'm not aware that these things have happened before. How we handle this is going to define how we respect criminal justice throughout generations to come. And I expect and I know that the institutions of state are capable of ensuring that we have a fair trial for these people. It does not mean that the accused person should be left to go, but it means that some changes in the prosecutorial department of government must happen. Otherwise, then there cannot be progress. Because at the end of the day, like I said, there is no way with all these things you will put someone in jail and the person will have that expected free mind to accept the verdict. Clearly, it is not. It is not something that we can do. And it may, when things like this happen, let's go back to history. When strange things happen in a country and things they've never happened before, what we often do is to set up a commission of inquiry. So if you look at all the commissions of inquiry from May 9 disaster, from all the commissions of inquiry, Ayawaso, it is when things like this happen, which have never happened before, and we want an honest and open conversations about them, and we want a permanent solution to some of these things, we set up a commission of inquiry to have an open conversation.
And that's what you are leaning towards.
Yeah, that is what I think should happen under this, because it goes beyond a simple trial of some 2-3 people. It goes deep into the criminal justice system. It goes very deep into the office of the Attorney General. And it goes beyond that. So, and the citizens want something. They want every Ghanaian wants to see fairness. Every Ghanaian wants to see fairness. So I think we should be looking at a commission of inquiry, or at least a parliamentary inquiry into this.
Okay, to settle issues. Well, let me bring in Isaac Wilberforce Mensah. He agreed to join much later during the show so he can respond to all the issues that have come up so far. Thank you so much for joining us via Zoom too, Wilberforce. So at least for those hearing or listening to us or talking about this issue for the very first time, the concern or the key question for them is the Attorney General and his representatives were in court when this particular allegation was made by Richard Jakpa. At least he's issued a statement revealing issues about the immense pressure coming to bear on the AG. First off, please, can you tell me where this pressure is coming from? At least he's mentioned Dr. Kaysel Atuforcing himself. And he says he has video evidence. People are asked or pushing for that evidence to be put out. Maybe you tell us when it will be put out. But who else is giving the AG pressure about this particular case?
For now, what I can tell you is that the pressure is indeed coming from all quarters. And before I even move on, I'd like to touch on a few things that have been already said to correct the narrative. First, I'd like to say...
Maybe before you get into it, you can respond also to why there was no defense or, on the allegations that came up in open court. We didn't get the AG's department also deny it in open court.
But in open court, I don't think you expect it to be a fight. Samson is a lawyer. Shrimsai in the studio is also a lawyer. And they both know that it's not as if it's the Attorney General who was cross-examining the third accused person, Richard Jakpa. The Attorney General will have the chance to cross-examine Richard Jakpa. So it is not even tidy for there to be a back and forth in open court, especially when the matters stated by the same third accused person are not even matters in contention in respect of the offense to which he has been charged.
Did he not consider the allegations at the time they were made as so serious an allegation that at least he can make an intervention in court? Because from what my understanding, at least, Richard Jakpa got angry because there was an interjection from the Attorney General.
It's good you are saying Richard Jakpa got angry. So I don't know if you're expecting the learned Attorney General with all his experience to also respond in an angry manner, or to be calm and then respond at the appropriate time. He will have the chance to cross-examine Richard Jakpa, and if he finds it important, remember, the people or the two persons on trial are being charged especially for causing or willfully causing financial loss to the state. A meeting that happened several years later has absolutely no bearing on an offense that prosecution has established and was supposed to establish, that the offense was committed several years past. So that's something, and I'm very certain that if Samson was the Attorney General in that instance, I doubt he would do a back and forth, especially knowing that he would have the chance at the next session or the next two sessions to cross-examine the person. When you find it necessary to cross-examine on that particular,
are you under the impression that that is my view, that the Attorney General should have said in court?
I'm under the impression that you are aware that it would have been very untidy if a back and forth had gone on, especially knowing that you would have the chance. You would have the chance
to me. The reference
to me. Let's just say.
I'm telling you, get this clear.
Any lawyer.
Listen to me.
This is my time. If you are saying that.
No, listen to me. Listen to me for a minute. You have been mentioning my name.
It's fine. It's fine. You've been talking for 45 minutes. Allow the shows.
Even if I've been talking for an hour,
I have not raised an accusation against you.
Can you listen to me?
Allow the Attorney General to also make their position on this.
I think it's my time.
Samson, please let Wilberforce complete that.
I've removed your name. I'm mentioning the name of another lawyer.
No, I need to say this removed. Unless you want to obfuscate what is happening. Listen to me.
Samson,
I don't think you want to be a
please, let's do this one at a time.
I have not said
to explain what has happened.
I have not said anywhere that the Attorney General
ought to
have answered in the court. I know well and better enough that there was somebody under cross-examination and there was no opportunity for the Attorney General to reply the person under cross-examination. So stop making imputations if you haven't heard me say anything to that effect. Okay. I know well enough.
If you listen to me, you know that what you just said is exactly what
please go on. Please go on with the point you're making about this. So you've mentioned that the AG wants to take his turn another time. Wilberforce, you're trying to address other issues.
One thing I want to say, and even though this little back and forth, and Samson, I still respect you a lot, I must say, especially because in Samson's submissions, Samson always made his submissions conditional. If indeed
Wilberforce, please, I have asked you specific questions. If you could stop
and I've answered your
making reference to something. I've asked you specific questions that you have not responded to, but it appears that you keep on, directing it to Samson. Please. Let's speak to the issues.
To something. I'm directing it to a matter that was said, and I'm only making reference to the person who said the matter. Unless I'm not supposed to make reference to the person.
Samson did not say that the Attorney General should have responded in court, at least. Not on this show. Okay.
I have even moved away from that.
That's fine.
Unless I'm not allowed to talk again.
You are, please.
Very good. So what I'm saying is that in Samson's submissions, because he was the one who made those submissions, and this statement I'm making is not to criticize Samson, but to rather applaud him, to say that in making his submissions, he made everything conditional, that if the Attorney General asked the third accused person to fabricate evidence, then there's a problem. If the Attorney General did this, and I think that's the position that everybody ought to take in this regard. Now, the Attorney General has stated emphatically that he has not at any point asked the third accused person to fabricate evidence. So if there is any such proof under 213, as Samson has been graciously provided, if there's any such proof of fabrication of evidence that in the said recording, which they say they have evidence of, if in the said recording it comes out that you you should go and fabricate evidence, whether it's said directly or indirectly, then the conversation is a different conversation. But the Attorney General in this instance has emphatically denied same. And I'm saying on authority that what the Attorney General told Mr. Jakpa was that speak the truth. Speak the truth. When we go there, speak the truth when we go to court. If I ask you, for instance, if I ask you a question on this particular document, speak the truth. Don't try to be...
So please, if I could come in on this particular conversation that the AG had with Jakpa, telling him to speak the truth, was this conversation had in the presence of Mr. Jakpa's lawyer, you would say? This meeting that you talk about?
Very good. That's a very good question too. And I'm glad also that in making or in commenting on that, it was said by learned counsel that if indeed there was such a meeting without the lawyer, a person who is not legally represented, or a person who is legally represented, and without his lawyer present, then that also raises question marks.
So I asked specifically, was he there? Specifically, I'm asking a specific
Let me correct
question.
the narrative. At the material time that these meetings took place, or this meeting took place, Mr. Jakpa was not represented by counsel. Now, if you look at Act 1079, a person, an attorney general or prosecution can do these plea negotiations either with the attorney general either with the accused person or his counsel. Now, this particular accused person, in the course of this trial, has changed lawyers about 4 times. This particular accused person started with, I think the lawyer on record initially was Randolph Tumisi, and then moved on to, I think, one Eko Kosa.
But I'm not sure there was any point in time that he did not have representation, for which reason a meeting will be held with him in the absence of these lawyers.
MFA, you are assuming. There's been a lot of assumptions that have been thrown out
But
there.
at least we've all followed this case. It's a public case. There is no point that Mr. Jakpa was not represented.
MFA, if you allow me to talk.
But you need to give us answers, Wilberforce. You need to give us answers.
If I'm giving the answer and you are talking, how do you get the answer? Let the people benefit from this, please.
Okay, respond.
So what I'm saying is that if you had followed this case, you would realize that even when he was asked to open his defense, he did not have a lawyer. He started giving oral testimony on his defense. So there were several instances where he did not have a lawyer.
Okay.
There were several instances when he did not come to court. There was not even a lawyer in court representing him. And these are all matters on record. So at the time the incident happened, he did not have a lawyer. When the plea negotiations started with the learned counsel, Thomas Obin, the Attorney General was negotiating with Thomas Obin. You can see from the correspondences that are out there, and the correspondences out there, or the letters that we see out there between the two parties. And I repeat, with the greatest respect, Mr. Srimsai, it is not the Attorney General who released those letters. So let's not make certain emphatic statements, for instance, that the AG has released those letters and that the AG has never, and also that the AG has said that people are guilty, which are prejudicial comments. He has never said that. He said he has closed his case. Now let's move on. At the time when these negotiations started, the Attorney General was negotiating with the lawyer, Thomas Obin, in this regard. As the negotiations continued, the accused person has fired or had fired the lawyer at the time.
Okay, so at the time that meeting happened, he didn't have a lawyer. That's what you're saying. We are really out of time. We're running out on this. That's why I'm asking the specific questions so we can get specific answers. So this 6 weeks ago meeting that was held at the Supreme Court Justice's home also, at that time, Jakpa didn't have a lawyer.
That's what we are saying. So therefore, it was a bit more reassuring for the Attorney General to know that there's a Supreme Court Justice who is a relative to the accused person. So his presence, of course, would be in the best interest of the accused person. This is not Sebio Hisebu Champagne. This is a justice of the Supreme Court. So when the Supreme Court Justice invites the Attorney General to come over, and in that said meeting, Richard Jakpa shows up, and then the conversation continues in respect of the plea negotiations, then I don't think the Attorney General has done anything wrong, especially as I pointed out, that at all material times that they met, the third accused person was not represented by counsel. MFR, you are a very good friend, and I'm sorry if I've sounded a bit, and apologies to you, Samson, as well. But because of the time, I need to put this information across because there's a lot of misinformation out there.
Okay.
So the Attorney General, at the times he met the accused person at the house of the Supreme Court Justice, at the instance of the accused person, the accused person was not represented by counsel. Okay. And even subsequent to that, when the accused person was represented eventually by counsel, counsel in this particular instance has even had discussions with the Attorney General. So these matters are being completely twisted out there. And the issue of fabrication of evidence...
So the Attorney General insists he did no wrong in this particular matter, even though you admit that all these meetings were held in the absence of Richard Jakpa's lawyer, or you insist that he didn't have representation, for which reason these meetings were held. He talks about video evidence...
I just want to add, sorry, before you go on, respectfully, I just want to add that if you read exactly what I was in court that day, and I heard exactly what the accused person said, Richard Jakpa said, at no point did Mr. Jakpa use the word fabrication of evidence. The word fabrication came in, or the issue of falsifying evidence came in outside the court when the Director for Communications for the NDC had a press conference and brought in words about fabrication and all, or brought in things about fabrication. It was never mentioned by...
But at least you mentioned that he's being forced to open the Pandora's box. Did that come up?
Yes, that came up, but that's not fabrication.
Okay.
What he said was that you have asked me to, in a nutshell, to testify against or to say things that will implicate first accused person. And what we are saying is that the Attorney General asked him to say the truth. The Attorney General presented him, look, this is the evidence that we have against you, and this evidence is already on record. This evidence has already been tendered. Remember, we've already closed our case. So the evidence is already before the court. So that's all the Attorney General did.
So all he told him was to just to say the truth. That's what he told him.
Truth. If I ask you this question, don't be clever about it.
Okay.
Don't be coy, don't be cunning, just speak the truth. If I ask you this question, this is what you say the truth. That's all.
Okay, so I'm sure that it's come to the public notice that indeed there's a recording, at least the AG also put in his statement that he has video evidence of the minority leader pleading for an end to this particular case. On the other hand, also we're hearing about a tape, at least an 18-minute tape or so, involving the Attorney General when he was actually asking Jakpa to do the things that he does. Is this really, this video evidence that we talk about, is there a point in time that the general public will have a feel of it or get to put it out in the general public? Is that going to happen?
Or if it becomes necessary, it will come out. But as far as the Attorney General is concerned, he is focusing on his mandate.
But you've heard the lawyers, at least, they've quoted the law. There's Article 18 of the Constitution, amongst others.
Very well.
For which reason this particular recording was done? Was it for a prevention of crime? What was the circumstances under which this recording was done? Secretly on the blind side of Dr. Atufosi.
It's painful that you're also using the word secretly.
Okay, it wasn't secret.
No, but it's not a secret.
No, I'm talking about the recording. The recording. Mr. Atufosi knew that the video recording was being done.
The only secret recording we know is the recording by the third accused person.
So Atufosi is aware about this recording. So Atufosi is aware about this recording, Mr. Mensah.
If there's a for instance, if you go to a hotel and there's a recording of you at the hotel in a public place, that's a secret recording.
Okay.
You don't assume that every recording that you are unaware of, that you are being recorded, is a secret recording. So I'm saying emphatically, I'm not going to give more facts about this, but I can assure you 100% that it is not a secret recording. So Article 18 is definitely inapplicable.
Well, but is the AG concerned about the turn of events in terms of the public opinion about this particular issue? It turns out that it looks like it's a political persecution, much more than a persecution. How does he respond to that? I'll be coming to you, Samson and Shrimsai, so that we can wrap up on this.
Just a quick question to Wilberforce. Is he saying that there's a recording that was done with the consent of the person who was recorded?
I asked that, but I didn't get a response to that.
No, what I said is that it's not as what you want to find out is if it's a secret recording.
So I asked you if Dr. Ato-Forson is aware about this recording. When you go to a hotel, they write it there. There are CCTV cameras here. Whatever you do is being recorded. That's why I'm asking if Dr. Ato-Forson is aware that this particular recording was taking place.
Whether he's aware or not, I'm not in his mind. I didn't see what he was seeing at the time, so I won't be able to say whether he was aware or not. But what I can say, based on what I know, is that it is not a secret recording. That I can assure you.
If he's not informed beforehand, if he's not put on notice, then you are talking about a secret recording. A recording that breaches his privacy, except it is for the exceptions provided under law.
And I'm telling you something, that things are not always black and white, especially in this regard. Whether or not he was aware, one would say that he ought to have known based on, as for instance, maybe where he was. But what I'm telling you is that it's not a secret recording. The Attorney General is aware of the law, as we all are, and would not record anybody without their express or implied consent.
Okay, so I was asking before I go to my guest so that we can wrap up on this about the AG and whether he's concerned. Because I'm saying let's wrap this up nicely. So whether the AG is actually concerned about the public opinion and the turn of events when it comes to this particular issue, that it's a political persecution rather than a legitimate prosecution.
Okay, so the AG is actually, to be very honest with you, I've interacted with him. I've been to his office several times, and his focus is, you go to his office, he's working. As I'm speaking to you right now, he's still at the office. He's working. His focus is on delivering his mandate as best as possible under Article 88 of the Constitution. So this issue, especially one that does not in any way touch, even remotely, the substance of the matter in court. The fact that documentary evidence has been provided in court, the fact that a case has been established to which the court has asked the accused persons to open their defense, I don't think these are matters that should bother him at all.
Okay. Mr. Shemsai, you have an intervention.
I am particularly, it's interesting because it appears the AG spokesperson, my very good friend, is focusing on the substance of the matter. The substance of the matter, the man has committed a crime 5 years ago or 10 years ago, long before this AG. But that is exactly to move away from the point. Criminal trial is about procedure. It is about fairness. So it is not even about whether you did the thing or not, but the court process must find you to have done the thing. That is why if you go and arrest someone and you don't even do the arrest well, they could nullify the whole trial. So to make it seem that we are just interested in the substance, criminal law is more procedure than any substance. If you have committed a crime, the process will determine. So, and I would not be happy if I were an accused person, or I would not be happy if I was a lawyer. Yeah. And in my trial, you have all these things going on. And you see, the impression is created as if Mr. Japa said only one thing.
And he says there's more.
Most of the things relating to this trial came from the AG statement. This video issue we are talking about, the begging from people, and all the things that we are even talking about came from the AG's own press release. So to make it look as if AG did nothing and it's only Mr. Japa, and since Mr. Japa has not provided further evidence, we should disregard it, is to try to misconstrue the whole thing. Nobody would have been more concerned if the AG didn't say, for example, that he has a video recording of someone. I mean, who would know that he's being recorded and then will sit down and be begging, please forgive me, let this matter. You know, it is the context of the video recording provided by the Attorney General doesn't show that the person is referring to is aware of the recording. Yeah. And secondly, the Attorney General says people have been coming to put pressure on him. This is Ghana, okay? We have so many, anywhere you are, whether you are a cleaner in an office or you are a food vendor, people will come and beg you to bend the rules. Why is it that it's only this Attorney General? As far as my law practice is concerned, I have never witnessed any Attorney General coming publicly to complain that people are putting pressure on him. And that tells you, see, the motive behind that press statement is to create an impression that these guys are guilty and they are just trying to find a way of escaping justice. Basically, that's what the statement does. Everything in this statement is to the point that they are guilty, and they are trying to, and I will show you, look, they've come to me to beg, they've done this, they've done this. That is basically what this statement is doing. And this is unfair as far as criminal justice is concerned, or any proper criminal procedure. These things cannot happen, and you will tell me that let's go to the substance.
Okay. Well, something in wrapping up with you on this as well.
I would like Wilberforce to think about it more carefully, that some of the confirmations that he makes, yes, they may not be about the substance towards the recovery or the prosecution to secure conviction over the 2.4 million euros. Is that what we understand? The 30 ambulances that were said to be, just bare buses fitted with kitchen panels is concerned. But the confirmations make the issues murkier and make it even important for those of us who are seeking to give education to the populace that there's a need to go into the matters. His confirmations suggest that the accused person did not just say things that are not true. There will therefore be the need for the purposes of, in the interest of all the parties, in the interest of the Office of the Attorney General and justice delivery, that these matters are gone into thoroughly. And so in the end, we know, who has done something wrong, who has not done something wrong, who faces what consequences, and who doesn't face what consequence. It will be very important going forward.
You welcome a call, for instance, for a further probe into this matter, Wilberforce. I would like to find out, and whilst the AG gets his day in court, for instance, does he consider that he's been defamed, and is he going to take any action? So 2 issues. Maybe you tackle the issue about whether he considers being defamed in this particular matter, whilst we wait to have him also cross-examine Japa. First off.
Well, that's his choice to make, or that's a route for him to take. Whether
that hasn't come up yet, has it?
Whether or not he's going to follow the path of chasing a defamatory issue. Remember, he's also the Minister for Justice, or a presidential appointee. So as to the sort of things that have been said about him, the sort of words that have been used against him in previous times, I mean, if he has not reacted to any of these, why would he react to a person saying that you met me, or you asked me to implicate another person who's also accused, when same is lawful under Act 1079? I don't think these are serious matters. They are not
serious matters when it actually borders on his professional conduct. It's not
if
serious.
If it's to chase everybody who's made certain harsh statements about him, I think he'll be chasing quite a few people around. But like I said, his focus is on delivering the mandate given to him, to his mandate, serving the people of Ghana as best as he can in his role as Attorney General of the Republic of Ghana.
And do you lean towards a further probe into this particular matter, knowing that it looks like there's more than what meets the eye?
Whatever comes out subsequently would go to, I mean, of course, he's an open book. The Attorney General is an open book. Whatever comes out subsequently would actually go to the disbenefit of the accused persons in this matter. Remember that these meetings were had in the house of a Supreme Court judge who is a relative to the same accused person, who was trying to help the same accused person. This same accused person went to his own relative's house with a recorder to record a conversation that was to his own benefit, twisted the narrative, comes to court to throw tantrums, and we are where we are. So a further probe, well, the Attorney General is an open book. So anything that comes out from such a probe is actually going to go to his own disbenefit.
Okay. By the way, how many meetings did he have with Mr. Japa? How many meetings are there?
I can't say for certain how many. I can't say for certain, but what I can say for certain is that the Attorney General at no point in time met Mr. Jakpa at any other place aside his own relative's house, which is the Justice of the Supreme Court, at the instance of the same Mr. Jakpa.
Okay, I'm tempted to ask which Supreme Court justice is this, but I'm sure you would not tell me. So I'll leave it here for now, or you tell me.
The Ariba number you have dialed cannot be reached at the moment.
Wilberforce, I'll leave it
sorry,
here.
this
That's
cannot happen.
Isaac
Thank you very
Wilberforce Bensa. He's a lawyer, spokesperson to the Office of the Attorney General and Ministry for Justice. We also had Samson Ladia Yanini, his lawyer, host Newsfile in the law, and Justice Shremsai, his lawyer, senior lecturer, University of Ghana School of Law. Thank you so much, gentlemen, for your time here on The Probe. There's more when you log on to myjoyonline.com. Interesting week ahead. Do stay with us here on our Joy News channel. I am Emefa Apau, and this has been The Probe.